Good afternoon. My name is Marc Davenport, and welcome to Straight to the Top, an exciting show that's committed to bringing you quality information for your personal and career development. Our topic today is on wills and estate planning, and on that note, it's my pleasure to have the distinguished John Sullivan, Esquire, who is providing quality estate planning advice in this community for over 20 years. John, welcome to Straight to the Top.
Mark, thank you. It's a pleasure and an honor to be here today, and certainly the issue of a basic estate planning is important to everyone in the community. Fundamentally, a good estate plan starts with a meeting and a full understanding of a good financial plan. A good financial plan starts with the client realizing and committing themselves to meeting with someone as experienced in financial planning as you to organize their thoughts, their needs, take a look at the financial asset base, and then make decisions which direction the client wishes to progress with a will.
Good point. Now, this is an issue that's dear to me. My father died in 1980 without a will.
Yes.
My mother died in 1983 without a will, and my parents had 10 kids. So that left us in a pretty awkward position. So we don't have a lot of time. Let's get right into this. Bottom line, what happens to the estate, for example, of a single parent with kids who dies without a will?
Well, in the state of Delaware, where I principally practice, we have estate planning guidelines provided by the state of Delaware.
Okay.
And in particular, our statutes indicate clearly that the state of Delaware will view an individual passing as dying without a will, better known as intestate succession. Intestate simply means that one dies without a will.
Okay.
If you die testate, you die with a will. If an individual passes in the state of Delaware without a will, the intestate statutes in Delaware would control the passage of their assets to their heirs and family members.
Define control. Does the state actually determine who gets what?
Well, the statutes actually are so precise that they will identify those assets, both real and personal property,
Okay.
that will pass to the individuals who survive. The statutes identify surviving spouses, children, brothers, sisters, descendants, and ascendants, mothers and fathers, who may survive at time of death and may take under that particular statute. Intestate succession, however, is not, in my opinion, the best way to plan both an estate passing, a person passing in an estate, or any financial plan, because in that regard, you're letting the state of Delaware control and or dictate how you wish your assets to pass at time of death.
Then let me ask you this question. When my mother passed, I had a sister who was 15.
Mm-hmm.
What happens if a parent, single parent, predeceases a minor child?
In that situation, again, if you die without a will, the intestate succession will clearly indicate in the statutes if there is a surviving child and no surviving spouse, that the child will take the principally under the estate. However, there are many techniques in true creation of a will that could function the same way and do it much better. In fact, if the individual decedent during his or her lifetime,
Decedent, I'm sorry.
decedent is the term for an individual who passes under an estate. The individual that passes during his or her lifetime could create a document known as a will. It's a written document, notarized, signed in the presence of witnesses and notary, and they will, that particular document, if prepared correctly and properly structured, will instruct how the assets are to pass at time of death.
Okay.
That is a much more orderly, much more efficient, and much better approach administratively to passing a property at time of death. The greatest single concern I have as an attorney is to make sure that everyone knows, everyone, that they should be in control of how their assets pass to their heirs and not an intestate law.
Then let's expand on that point. I'm going to ask you a two-part question. The first part is, does everyone need a will? Should everyone have a will? And then secondly, I'd like for you to tell the audience about the basic estate planning review process.
The answer to the first question, Mark, is unequivocally yes. Everyone should have a will.
Single, married, regardless?
Regardless. The purpose of a will, and fundamentally, is to simply create a document that allows the individual that is passed prior to his death or her death to identify those heirs precisely who they think will benefit most from those gifts. A will is nothing more than a document that evidences gift at time of death. In essence, a testamentary gift.
I have a client that's an elderly person. She's widowed, no kids. What happens to her assets at the time of death?
If she has a will, she has dictated clearly in that document how those assets will pass to her identified beneficiaries under that will. She passes, then the individual who is identified within the will by the name of an executor. The executor is the individual charged with the duty of taking the will to the Register of Wills along with the death certificate and identifying through that process. A basic will be probated through Newcastle County Register of Wills in a fairly defined process called probate. And that will, after being registered, would then be processed and close the estate through that process known as probate.
Now let's get into the heart of the matter. Let's say, for example, I'm coming into your office. We're meeting for the first time. I'm referred to you. I don't know anything at all about wills or estate planning. What sort of information should I bring to the initial meeting, number one? And number two, please give me an overview of what happens. Explain to the audience, okay, the basic estate planning process.
There are two important questions. The best answers to that question, both questions, are as follows, Mark. I believe that any attorney that's assisting a client with a will needs to understand that client carefully. Not just how much that person owns or the asset picture of that person, but to understand the person's needs, to understand the person's desires, their concerns about their family, their concerns about their relatives, how they want to structure their gifts. Once that is accomplished, and that's generally through an initial meeting, I will draft a basic will and send that will to the client for review. During that same process, we also send out forms that allow that ahead of time before the meeting in my office with the client to identify individuals, identify who they are, their relationship to the individual that's creating the will. Second question, how important in the process is meeting with the client and understanding its an ultimate importance. There's no substitute for understanding the client. That process is a one-on-one process. I generally, when I meet with clients as a husband and wife situation, I've had clients ask me, can I come in your office without my wife or my husband? And the answer is no. I want to meet you both together so we can have a dialogue and understand both.
Then question, married couple, is there such a document called a joint will? Does each spouse need their own will, or what's the process?
Excellent question. There is confusion about that. There are, in my opinion, there is a document created for each individual. Husband and wife must each have a separate document because normally, there are exceptions, but normally husbands and wives die separately. There is a process recognized in Delaware called simultaneous death, but even in that case, the wills are probated separately. So each individual must have a separate document that identifies his or her desires at time of death.
Okay, so it's best then for each parent to have their own will.
No question.
Okay, how often should the wills be reviewed and updated?
An excellent question again. I generally tell clients to at least, after their wills have been prepared, to review them at least once a year. Not so much time-wise, it's just a vehicle to make sure that they have a regular review. Okay. In addition to that, I like to have clients review their wills whenever there's a substantial change in their economic circumstances, their domicile, meaning moving from one state to another, or social changes. Unfortunately, sometimes divorces happen in people's lives, and their documents, especially their wills, must be reviewed carefully in order to identify their needs after the divorce has occurred.
What if someone inherits a significant amount of money or has a substantial increase in their net worth? Is this the type of an event that should trigger an update, a meeting, a follow-up?
Well, certainly that's, again, a follow-up to our last question. But fundamentally, I go back to my original statement about that. If there is an economic change in one's circumstances, the client should be meeting with a qualified financial planner to understand how that particular asset accumulation and protection can best be structured for them during their lifetime.
John, we're going to have to stop there. We're going to take a break. Stay with us. We'll be back in a minute.
Mark started his investment career on Wall Street in 1985, and he would like to share his business philosophy with you. To provide goal-oriented financial planning and investment advice for investors who do not have the time or the experience to do so efficiently for themselves. A sound financial plan should take into account your investment goals, risk tolerance, and time horizon. It is also important to maintain realistic expectations based on the market's historical performance rather than unprecedented returns of the recent bull market. My commitment always has and always will be to take the best care possible of all your hard-earned assets. To schedule an appointment with Marc E Davenport, please call his assistant Tammy Bolden at area code 302-683-3629 or send your email to markedavenport@prussec.com.
Welcome back. Let's continue the discussion with John Sullivan, Esquire. John, let's talk about review of estate plan documents, wills and trusts.
If a client comes to my office and already has a will in place, certainly I would want to see that. If there are particular modifications that are necessary, we can accomplish that sometimes with a form called a codicil. That's a fancy word for...
I'm sorry, can you repeat that?
Codicil.
Okay.
That term is simply an amendment or a short version of a change to a will. If a modification or a redo of the will is necessary, then we'll simply take a time to understand the client's needs and restructure the entire document.
So at that meeting, though, you wouldn't suggest that the client bring a copy of whatever documents they've had?
Yes, and certainly we'll be looking at the will itself and whether or not there are any changes necessary in the will to make sure that the client's needs are met at that time.
What is a durable power of attorney?
That is a document created during one's lifetime, and it's effective during one's lifetime only. We've talked for the last few minutes about wills, and they are testamentary instruments. A durable power of attorney is a document that identifies an attorney in fact and or a personal representative for that individual under that document. And the attorney in fact may be an individual that is a trusted individual that would operate and or act on behalf of the individual creating this document for the protection principally of the individual.
So when you say an attorney in fact, you're not specifying that it must be an attorney?
No, it could be anyone that is competent, that is an adult over the age of 18 in the state of Delaware, and could be appointed for that individual if that individual has a mental or physical infirmity that arises at that point or in the future. That individual could step forward and handle that individual's financial affairs or personal affairs for him or her.
Well, you touched on my next question, and that is who should consider adding, is that the correct term, adding a durable power of attorney to their will, and under what circumstances is it advised or suggested?
The durable power of attorney is a separate document, separate from a will.
Okay.
However, its function is during one's lifetime. And clearly the durable power of attorney is necessary for almost everyone over the age of 18.
You said it is?
Yes, it is.
Okay.
Many people, particularly husbands and wives, the example I give is that the theory is in many people's minds that if they're married through a contract of marriage, that the husband and wife can normally be recognized and act on behalf of each other if there's a financial problem or some other issue arises. For the need for the power of attorney arises, And in that case, clearly what happens is, without that document, those individuals may not be able to act on behalf of each other.
Even if they're married?
Correct. For example, a husband is unfortunately in a disabling accident and is comatose for 5 or 6 months, cannot act on his behalf. Can the wife go to his employer and ask for his last paycheck, or activate disability insurance coverage, or deal with the Internal Revenue Service? Generally not without a power of attorney. One should have a power of attorney even in the situation where husband and wife.
So for everyone in the audience that's watching this show, ask yourself this question. If you're married, do you have a will? Secondly, do you have a durable power of attorney? And if you're a single parent or a single person, based on the information you just gave, I would imagine that it would be very important for someone to give a close person, family member, etc., power of attorney.
There's no question in a single parent situation that's even more compelling, if not critical. The trusted individual that's appointed under the power of attorney would act on behalf of that individual who is disabled and or infirmed, and protect the family's finances and manage those issues for that particular individual that's disabled.
So a durable power of attorney sounds like it's probably a pretty important part of the process.
Absolutely necessary part of the estate planning and financial planning.
John, tell the audience about medical pre-directives. What is a medical pre-directive?
The state of Delaware has a statute called Death with Dignity, and quite frankly, that medical pre-directive addresses that issue. Many people in our community look at medical pre-directives and use another term for identifying those documents. They call them living wills. They're not really wills, and they're not really living. They're better called medical pre-directives.
Does that deal with the question of right to die?
And to some degree. The medical pre-directives' intention is to appoint a personal representative under that document to deal with doctors and hospitals and nursing homes and those kind of critical situations where an individual may be classified or identified as terminally ill, and that individual would step forward for that person and act under that medical pre-directive to make choices whether to continue with artificial means to maintain the living process.
So if someone is attached to a respirator because they can no longer breathe under their own power, if I'm hearing you correctly, what you're saying is if a person has a medical pre-directive established, then they could have made a decision prior to being in that position. If I find myself in this position, John Doe or Jane Doe has the right to make a decision to pull the plug, if you will.
In essence, it's not exactly that easy pulling the plug. The medical community will tell you that it's a much more laborious process of determination of terminal illness condition, but clearly that is the intention. That individual's intention is to act on behalf of the individual who is terminally ill and make those critical decisions in those circumstances.
Are you starting to see more and more of this?
Most of the clients I represent, probably about 98% of the individuals I represent, participate in medical pre-directives.
98%. Review of estate planning opportunities. Gift tax annual exclusion. What is that?
Well, certainly this plays into the importance, quite frankly, and I want your viewing audience to understand that estate planning is fundamentally a sound approach to passing assets at time of death, but it requires that they take a good look at their financial plan. And quite frankly, the issue of gift tax and the issue of making gifts during one's lifetime to family members and the gift tax exclusion is something that's done during one's life. Right now, the IRS, Internal Revenue Code in the United States, allows a gift tax exclusion up to $10,000 per person per gift to individuals. For example, to better understand, a husband and wife married wants to give a gift to their daughter, they can each give $10,000 with the gift tax exclusion. The exclusion relates to the federal unified credit amount. Federal government at time of death will impose a federal estate tax if one's estate exceeds $675,000 in this calendar year. If one
Good afternoon. My name is Marc Davenport, and welcome to Straight to the Top, a show that's committed to bringing you quality information for your personal and career development. For those fathers watching today, we'd like to extend a very happy Father's Day to everyone. Go out and enjoy yourself. We've got a great show today, a very special guest, and on that note, let's get right into the heart of the matter. On my left, I'd like to introduce Dr. Tony Allen, president of the Metropolitan Wilmington Urban League. In the middle, the lovely Helen Foster Parson, the economic development director, also of the Metropolitan Wilmington Urban League. And on my far left, Mr. Charles Madden, who sits on the board of the Metropolitan Wilmington Urban League. And as you may have guessed, today's special guest is the Metropolitan Wilmington Urban League. Tony, Helen, and Charles, welcome to Straight to the Top.
Thank you for having us.
Thanks for having us, Mark.
Listen, let's get right into the heart of the matter. We've got a lot of information to discuss. Tony, who is the Metropolitan Wilmington Urban League? What is your mission? And why do you think it was important to establish a local chapter here in town?
Well, the Metropolitan Wilmington Urban League is a part of the National Urban League, which is a 90-year-old civil rights movement.
Okay.
And our mission is to enable people of color to secure economic self-security, parity, power, and civil rights in the 21st century America. And the reason we started the Urban League here about 2 years ago is because we thought in order to do that, you needed a 21st century organization committed to those things. So at the Urban League here in Wilmington, we believe in two things. First, every child should have access to a quality education. Second, his or her family should have the ability to accumulate some level of wealth. So to those ends, we focus in two areas, education and economic development.
Okay, very good. What makes the Urban League different from some of the older and black groups such as the NAACP?
Well, the NAACP largely responds to situations, and we believe that's important in civil rights.
Okay.
We also believe there needs to be some proactive action taken on behalf of people of color, those folks who are sort of underserved and are not getting the parity and power that would make them whole citizens in America. So the Urban League tries to respond by, instead of talking about anecdotal evidence and the like, figures, convene groups, develop strategic plans, and once those plans are in place, make sure that those plans are implemented and are effective to the constituents we serve.
Now, how long has your chapter been established here in town?
Well, we're the